This is CPB's three seminar series on expert witnesses. Today, the first one, we're going to be thinking about generally expert witnesses, the who, what, where, why, how of experts, how we use them in courts, in arbitrations, etc. In the second one, I want to talk to you about working with your expert, both in terms of report writing and also the delivery of evidence before decision makers. And in the third part, we're going to switch it. We're going to be thinking about how is it you can dismantle the evidence of the expert in cross-examination, and we'll talk about techniques, approaches, and the key thing, spoiler alert, is something that I call the pyramid. We're going to touch on it at the very end of today, and I'm going to show you that, and we'll bounce into that for next week. Nobel laureate in physics, an expert's a man who's made all the mistakes which can be made in a very narrow field. Perhaps that's right. It's somebody who is very knowledgeable about one particular area normally. Often we have to ask ourselves, are you actually an expert? What does it mean to be an expert? Remember, generally, I can't think of many, if at all, any fora that individuals are not permitted to come forward and give their testimony as an expert witness. You do not require to be badged as an expert, formally badged, in order to give your evidence. And that is why expert witnesses are held to such a high level of accountability in terms of independence, impartiality, bias, assisting the decision maker, principal duty to the court, etc., etc. What we do know as lawyers is that the expert witness will furnish or supply some kind of technical or scientific input to the case which is needed. Are they a person of skill? A person who, through practice or study or both, is specially qualified in a recognized branch of knowledge, whether it's art, science, or craft, or I said technology. That's what the Supreme Court said in a case, Kennedy and Cordia. And they referenced this South African case, which is always brought up, Bonithan. It's always brought up in terms of the admissibility of the evidence from an expert. Before admitting the opinion of a witness into evidence as expert testimony, the judge must consider and decide two questions. The first is whether the subject matter of the opinion falls within the class of subjects upon which expert testimony is permissible. And that may be divided into two parts. Whether the subject matter of the opinion is such that a person without instruction or experience in the area of knowledge would be able to form a sound judgment on the matter without the assistance of witnesses. This carries on, possessing special knowledge or experience in the area. And B, whether the subject matter of opinion forms part of a body of knowledge or experience which is sufficiently organized or recognized to be accepted as a reliable body of knowledge or experience. The second question is whether the witness has acquired by study or experience sufficient knowledge of the subject to render his opinion of value. Now, those two parts there are always repeated in court judgments and discussions about expert witness testimony and the admissibility of it. If you think about it, as the modern world progresses, AI, ChatGPT, etc., new things come before the court for determination. And it is something, obviously, the court does not know about and requires the assistance of other people, put it that way, to help them understand these new things. And therefore, expert witness evidence may be required. As it says here, is there already a body of knowledge or experience in this area? And are you the right person to help the court with that? Here's something that's maybe not always appreciated. Now, we know the general rule is that examination of witnesses are on facts which fall within their own observation, and this is witnesses to fact, which are not opinion or inference for a judge or jury. But bear this in mind that the possible functions of an expert are to carry out investigations as to facts. So when later we talk about this pyramid, I'm going to discuss with you relevant facts. Not the burst mattress of facts that the solicitors have sent the expert, but the facts that the expert considers to be relevant for the purposes of assembling his opinion or her opinion. So, as has been confirmed by the Supreme Court, expert witnesses can also be giving evidence of the facts that they themselves have found. So they perform a dual function in that respect of those facts plus the opinion evidence upon which they based on those facts. Professional witnesses are kind of a hybrid. What I mean by that is your paramedic, your police officer, your prison officer, your fire officer, people who are carrying out a professional function. They're not often there to give opinion evidence, but you must remember the kind of questions which are, in your 20 years experience, have you ever seen, etc. So it's not necessarily expert opinion evidence, but comes very close to, and you will see in the decisions that the court is always open to accepting that kind of evidence, which is sometimes classed as professional witness evidence. And then finally, the one that we're here for today is expert witness, which of course is opinion evidence. As an expert, they are in a very privileged position, and thus they must always remember that they are not the hired gun, they're not the gunslinger. They must try to present as independent, impartial, and without bias. So people sometimes say to me, what's the difference between independence and impartiality? I suggest independence is an internal process. Independence is look inside your soul and think, can I truly, in the circumstances, act independently without any outside considerations or influences on me? Internal. Impartiality, if you look at the case law and the test, it's all about reasonable observers, third parties looking in and forming a view as to whether you can act impartially in the circumstances. That's the concept of impartiality. So one is subjective, independence. The other is more objective, judged by the test of a reasonable observer. Bias is either actual or apparent, ostensible. Actual bias is where you are actually biased by virtue of your self-motivation or self-interest. Apparent bias is far more dangerous for the expert. It is where they are biased, but they don't realize it. It is an unconscious bias. This is all why, again, when we get to the pyramid, I'm going to demonstrate to you one of the blocks of the pyramid will be this part. It will be whether the expert has carried out a self-assessment as to whether they can be independent, impartial, and act without bias. I'm going to come back to that. Next, do we actually need an expert? In my experience, there are situations where experts are brought in when experts are not actually needed. And this is a very well-known case where the court was striving to point out that if, second sentence, if on the proven facts, a judge can form her own conclusions without help of an expert, then the opinion of the expert is unnecessary, even if it's dressed up in scientific jargon. So we, the courts and us, have to think carefully, is it actually necessary for the expert witness evidence to be given? There are occasions where an expert is necessary, and you may know this already, that where there are allegations of professional negligence, certainly in England and Wales and in Scotland, in UK generally, you will have to get an expert opinion to say that the fellow professional has fallen below your Hunter-Hanley standard of reasonable competence, reasonable skill and care, acting reasonably. That will be required generally in court cases. You can't just make these allegations without a basis, and the basis is an expert opinion. Now, here's an interesting one. Some legal systems will only allow expert evidence with permission, and others will allow you to call your expert as you wish. And finally, arbitration falls into that latter category. So I thought what we'd do is, seeing as we have a Dubai audience here, look at the DIFC and the relevant sections of RDC. So, as it says there, 31.1, a reference to an expert is a reference to an expert is instructed to give or prepare evidence. And it refers to the English Protocol for the Instruction of Experts. This is what I want to point to, 31.13. No party may call an expert or put in evidence an expert's report without the court's permission. Same as England and Wales, part 35. That is, nobody can just call an expert willy-nilly. Goes on, under the RDC, when a party applies, he must identify the field in which he wishes to rely on the expert evidence, and where practicable, the expert in that field on whose evidence he wishes to rely. I actually think this is a good thing. I started out in Scotland where we don't have this, and now I practice in England where we do have this, and obviously we're having a look at DIFC. I actually think it's a good thing. I'm going to come on to it just in a minute, but it compels and forces the legal team to think as a matter of litigation strategy. Why is it that we actually need this expert? What function will they be performing? What evidence will be led? What is it we need to take from that expert in order to succeed applying the facts to the law? Just come on to that just a minute, but I think it's a good thing. So as I say, in my jurisdiction originally, we didn't have this, but there could be consequences at the end of a case. Now, what would happen? In fact, you know what? In Kennedy and Cordia, that is a Scottish case that went to the Supreme Court. And it was all about a lady who slipped on ice and whether she should have had something called yak crack spikes on the bottom of her shoes. And they brought along a so-called expert called Mr. Greasley. Everyone remembers his name, Mr. Greasley, who was purportedly an expert on slipping on ice. As you approached, it was a district nurse visiting somebody at home. She slipped and suffered an injury. But that's what the Supreme Court were noting, is in that Scottish procedure, they brought along all these experts, and that had cost consequences as to whether you could recover all of the cost. That's the way we did it. England and Wales, and in obviously the DIFC here, they require permission. Before we leave this, remember in arbitration, normally parties can call any expert they require. So unless it's limited in your procedural order number 1, which would be more or less unheard of, it wouldn't be for a tribunal to restrict the case being brought by either party. In arbitrations, the either party can bring forward any number of witnesses they want. Who appoints? Another important consideration. And we're going to look at court, and we're going to look at arbitration. So arbitration first, you'll appreciate each party will appoint the relevant expert witness, but it is possible also to have a tribunal-appointed expert. Everybody talks about savings in time and cost in arbitration and how it's a great idea and the Prague rules, etc., etc. It's a great idea to have this. I've never seen it practically. I've heard about it, but I've never seen it. Never had it in any of my arbitrations. And the reason for it is once the tribunal appoints an expert, often the parties appoint their own experts to comment on the tribunal expert. You end up with 3 experts instead of 2. The so-called cost saving evaporates. So as I say, I've never seen that, but it is possible to have a tribunal-appointed expert witness to the exclusion of any other expert testimony. You can understand why that might be. In court, we just looked at the provisions for parties seeking permission to appoint an expert. There is another concept in England and Wales called a SJE, single joint expert. That is somebody appointed by the court in a similar way to tribunal appointed experts. And there is provision in the DIFC RDC for a court appointed expert as well. 31.29 to 31.47. I think 29 is the one I've highlighted. The court may appoint one or more independent experts to report on it on specific issues. Questions. So again, differing approaches. When I operated in Scotland, we didn't have expert questions ahead of what I mean by this is where you get to ask questions of the experts ahead of the day on which they're going to give their evidence. So that didn't exist. It exists in England, Part 35. And I see that the DIFC has also followed that with written questions to experts, 31.24. A party may put to an expert or a court-appointed expert written questions. If you need an expert, you need to get the right one. This is a quote from a case where they talk about, it's quite a cause célèbre actually. It was a shaken baby case, and the expert witness was a very, very experienced anthropologist, pathologist lady who was a professor, dame. And what had happened was that the prosecution had pushed her into expressing a view which strictly was outside what I would call the realm of competence. It was outside what she was qualified to give evidence on. And it sneaked into her report. She was shredded in cross-examination and publicly humiliated by the judge who referred to her as a quack doctor. She never, ever gave evidence again, ever again. In any case, she found it so bad. But this is what the judge said, that you need to have relevant qualifications, competence, expertise, and experience to speak on the matters you're invited to give evidence about. What I call realm of competence. You have to, as an expert, stay within what you're qualified to give evidence about, what your knowledge is, experience, and expertise. Qualifications, as I've said, you don't actually need qualifications, but you need to satisfy the court that they have the sufficient expertise or experience to give that evidence. Sometimes it might be academic as opposed to practicing. In this case, the court found that the witness had no practical experience before, and therefore his evidence was hypothetical and of little assistance. So I do quite a bit of work with expert witnesses, and I sometimes say to them, you've got a burst pipe in the house. What do you prefer? Do you prefer the guy that's been working for 25 years, the old lag who comes along, fixes a pipe, as he's done for the last 25 years, pipes fixed, no problem? Or would you prefer the guy who's disqualified, knows all the new techniques, he's got all the new materials, and can do just as good a job, if not better, albeit he's got no experience? Expertise versus experience. So it's not always the case that somebody who's done it a long time will make the best expert witness. It also follows that somebody who has done it a long time but has retired faces a very real risk that their knowledge is out of date or stale if they haven't kept abreast or kept up to date with current and modern developments. It also follows that they would be susceptible to challenge in cross-examination as to the fact that they have not had hands-on working experience for some period of time. So long experience is not always the best. Now, The next slide, do you know what that is? That is the Icarian reefer. Okay, a reefer, I was interested to find out, a reefer is a boat. And the Icarian reefer caught fire. And it resulted in a very long case. Let's go into the facts. A very long case that happened in the English courts. And from this case, Cresswell, Mr. Justice Cresswell, laid down a number of propositions to be adopted where expert evidence is being led. And as we'll come on to see, this is being replicated all around the world and informs many, well, we'll see. The IFC has actually followed almost exactly what he says here. What happened? The crew of the ship deliberately set it on fire on instructions from the masters. 8 experts were called. 1 expert witness spent several days giving expert testimony on the heating of a valve mechanism. The valve mechanism was not even referred to in the closing submissions. All in all, the piece of evidence was an expensive irrelevance. The judge viewed most of the expert evidence as being biased towards one party or another, or intended to conceal evidence from the other side. Goodness. So what did he say? What did the judge say? The role of the expert. 1, expert evidence presented to the court should be seen to be the independent product of the expert, uninfluenced as to form or content by the party instructing. So this is the independence part, the internal subjective exercise that the expert has to undertake that I was referring to a minute ago. Lo and behold, look at RDC 31.5, almost a mirror of what he says that expert evidence should be an independent product. And you'll see this all the way through. The RDC just replicates what Cresswell says of important principles. Number 2, an expert should provide independent assistance to the court by way of objective, unbiased opinion. RDC 31.6 assists the court by providing objective, unbiased opinion. An expert witness should state the facts or assumptions on which an opinion is based. RDC 31.7. Consider all material facts, including those that might detract. 4, an expert should make it clear when a particular question or issue falls outside his expertise. This is the realm of competence. RDC 31.8, an expert should make it clear, etc. So following very closely the principles of the Icarian reefer. 5, if an expert's opinion is not properly researched because he considers that insufficient data is available, that should be stated. RDC 31.9 follows that as well. 6, if after considering other side's expert reports, he changes his view on material matters, that change should be communicated to the other side without delay and where appropriate to the court. RDC 31.11 follows suit. A supplementary report may require to be produced in consultation with a party instructing. 7, reference to literature or any other material which may assist the court should be referred to. RDC 31.21. Unless they've already been provided, photographs, plans, analyses, measurements, survey reports, or other similar documents relied on, as well as any copies of unpublished sources, must be provided to all parties. The RDC has gone even further in terms of specification. 8, details of experts' academic and professional qualifications, experience, and accreditation should be in the report. That's also in the English Part 35, and the Practice Direction 35, that also replicates that. That may be the case here. If you remember, the RDC references that publication and therefore hasn't. That might be the reason why they haven't got an express RDC rule for that. But that is what a court would expect. Again, when we come to this pyramid, spoiler alert, the first bottom left-hand block is going to be CV to demonstrate experience and expertise, following Cresswell. So those principles, if you like, all 8 of them, are very often referred to in any of the subsequent cases on expert witnesses. They inform procedural rules, as we've seen with the RTC. I could look at the Part 35, it would be in similar terms. And will be, as I say, used in my pyramid that I'm going to come to for the purposes of compiling the report, as well as the delivery of the evidence. And as we'll look at in Seminar 3, the dismantling of that pyramid in terms of trying to take out these blocks because there's been a violation or a non-following of one of these respective principles. Okay, so you have the report from your expert. Let's just say you haven't had the opportunity of working with your expert that we're going to cover in Seminar 2. You have this report. It is meant to be, remember, independent, unbiased. And you're going to read through it. You're going to be checking for language in the report and content. We're going to come back to this next time when we think about how to draft a report, but we want to be looking for language which denigrates the other expert or criticizes unnecessarily the other expert gratuitously, or the other side's case in a non-balanced or partisan way. The other side are clearly not thought of. I'm surprised the claimants have selected, etc., etc. I'm going to come back to that in Seminar 2. The duty of the expert, another case expressing a similar sentiment, is to furnish the judge with the necessary scientific criteria for testing the accuracy of their own conclusions so as to enable the judge to form their own independent judgment by the application of these criteria to the facts in evidence. Now, experts sometimes say to me, okay, we get it, we're not allowed to express a legal view. So we know, don't cross that line, don't sail close to the line, don't say there's a breach of contract, don't say there's a breach of a duty of reasonable care, don't say there's a breach of a statutory duty, whatever it is, we know all of that. But what are we expected to do and still not say that there has been a breach? And I try to explain to them, well, where it says reasonable, you're going to provide your professional opinion on what is reasonable. If you're looking at contractual terms, make sure that your solicitors have provided you with contractual terms. I would have a go at you if you went searching for them in the contract without any legal input or advice, and so on and so forth. But what's been picked up here is ultimately it's for the judge to make that determination. And therefore, any expert report which purports to make a legal determination will be subject to challenge. In my 30 years, I hate to think, my takeaway is that legal and technical don't speak terribly well together, don't communicate well. And so I think I could put it this way. The problem perhaps arises where legal are at the very start of working out what their case strategy is or case plan is. And they know that they're going to need some kind of technical input. And they're busy working out what the facts, how do we prove the facts? Is it parole evidence, documentary? Is it inference? What's the law that we have to apply it to, etc., etc. And then there's that little gaping hole that says technical. You say, okay, it's the stone wheel man that we need. And off they go to grab a stone wheel man, who's delighted, of course, to get the instruction. Hooray, I've got instruction as an expert witness in stone wheels. And they take the instruction. And it's at that point that, in my experience, there's not the greatest of communication. So the stone wheel expert goes off and does his thing without really knowing what he's being asked to do. And the legal team think, that's great. The expert's going off and doing his stone wheel thing. We don't have to worry about that until we get the report back. Then the report comes in, and the report perhaps isn't on all fours as the case develops as well. That's the other thing. The case is developing from the very first point that the expert was commissioned. So miscommunication at the start can cause real issues. Next time, we're going to be thinking about how to instruct an expert, what to put in writing, and for the expert to use that instruction within his report, something we're going to come back to. So why is it the technical and legal? I've touched on it there. The legal don't always fully understand at the start what they are seeking in terms of a remedy, dare I say. Do they know the law to be applied? Do they know all the relevant facts to be applied? Are there secondary inferences to be drawn? Is there a gap? What kind, which expert, and so on? Just what I've covered just now. That's the other way, of course. And I say to my experts, please, please do not speak techno-babble. Lawyers are dreadful for legalese. Dreadful. It's the pot calling the kettle black. I know that. But please don't use your techno-babble. Try and explain it in the simplest of terms, if possible. I've even said as though it's to a well-informed 8-year-old kind of level, unless the court or the decision maker says to you, I understand this, or exceptionally, they are an expert in the field already. Again, we're going to come back to this next week, but experts aren't usually lawyers, and so employ English in a non-legal way. Here's some examples. The engineers should have advised the carrying out of sufficient investigation of the structure. Now, that's court practitioners that'll jump off the page at you. Why should they have been advised? What was sufficient? By what scale or level or tolerance or measurement was it sufficient? What is meant by investigation, etc., etc. So to the expert, you see, that might make complete sense, but throws up all kinds of issues for the lawyer. Let's look at some more. This clearly lays out their responsibilities. Well, clearly, I sometimes say to experts, anything quantitative, qualitative, distance, or time, be careful. So it's clearly, it's extremely. Okay. Quantities, likewise. Distance, it was miles away. It was 1.2 kilometers away. Time, it was ages ago. No, it wasn't. It was a week ago. So quantitative, qualitative, and distance and time are always the watch outs. Here's some more examples. Investigations were inadequate, as they were apparently not asked to investigate what test of adequacy. Is there apparently a presumption, and so on and so forth. I consider the drawings are incomplete. Is that expert opinion or best practice or breach of contract, etc., etc.? So what is quite acceptable in normal English to an expert may cause us, as lawyers, issues. What do you do about that? Okay, there's a balance to be struck. You're really stuck with what the expert says. The conventional wisdom is you cannot ask your expert to change his or her report to something that you like. The risk is, you see, in cross-examination, the other side, ask the expert, were you asked to change your evidence? Look at that point at the bottom there. I've seen this done. In fact, I've done it myself, where in a footer, the expert has accidentally put in V.4. V.4 is version 4 of this report, which then might open up a discussion about what was in the prior versions and what it was that he took out, etc., etc. Now, I appreciate in some jurisdictions that line of questioning is not permitted in arbitration. It probably would be. Anyway, the point I'm making is you can't tell them what to put in the report, but what you can do is highlight to the expert that some of the language or some of the concept or some of what they're saying might present them with difficulties. You might challenge or drill down, reality test what they say by arguing what the other side says. So a bit like the shepherd and the sheep, you can maybe try and push them along the road a bit without telling them what to say. There's a fine line to be walked. Back to Cresswell. If you remember, Mr. Justice Cresswell, he talked about the expert's CV, basically, academic, professional qualifications, experience, accreditation relevant to the opinions. And I keep making this point about what I call the realm of competence is utterly important, as was demonstrated by that Professor Dame. even one little titsy tiny toe outside the circle of competence may be enough to collapse the whole house of cards. I sometimes say to experts, why don't you put petrol around you in a circle and light it? And then do not put even 1 foot over there. You're going to get burned. I've seen it too many times where an expert has expressed a view that they're not entitled to express, and in cross-examination they accept that, and in submission it's then said to the decision maker, well, what parts of his evidence can we trust? If he exceeded and accepted that that part was beyond his competence, how do we know about all the rest of his evidence? So important. So the second point I would make on this slide is that perhaps not enough attention or focus is made by your own counsel at the start of the evidence given in any forum, arbitration or court, as to the qualifications that the expert possesses. Experts are always really surprised when I say to them, you do realise I go through your CV with a fine-tooth comb and I check everything. And I do a search for any publications that you've written which aren't on it, especially those which are contrary to your current view. And I check your social media. I do my homework. Because there have been experts, I look forward, it's on his LinkedIn, I look forward to being in court today where I'm going to say such and such. Really? Or they have omitted things from a CV, or there's gaps. This is a true story, I had a war story, but I had a case in arbitration where I had a technical boffin who was an absolute mastermind at computers and laptops, and the case was about what was on a laptop. And he was amazing what he could tell from this defunct laptop. But that wasn't the point. As we were going in, the other side said to me, why has your expert got a gap of 5 years on his CV? And I'll be honest, I hadn't spotted it. I didn't see it. And I had to go and ask him. And he said, So I'm thinking, either he's been in jail or he's a spook. He's a spy. And he said to me, I've signed the Official Secrets Act. And that was enough to go to the other side and say, I'm terribly sorry. He signed the Official Secrets Act. And it was fine. It was all fine. But the point of that is the other side had very carefully looked at his CV to prepare a line of questioning. Why is it that you've got a big gap in your CV? And the guy was quite surprised that that might be brought up. But it will be brought up. Again, as we get back to the pyramid, we're going to have a look at why that's so important. Cross-examination techniques. I'm going to save that for part 3. Now, remember, the legal test is ultimately for the court. We've made that point. Experts applying them a law or something, it's a breach of contract negligence. I think we've covered that already. The point is, they can't do that. Dangers for the expert. This is a bit of a heads up for what we're going to look at next time in part 3. Techniques to cross-examine them. The best, in my experience, the most effective with an expert. You see, if you ask closed leading questions of the expert, you're at the seminar today, aren't you? Kind of thing. All you'll get is yes, but no, but. Vicky Pollard, yes, but no, but. They never want to say yes without context, elucidation, or explanation. And so sometimes it's most effective in cross-examination to do what I would call a garden path. Lead them right up a garden path. Either we go too far to come back, or we go off a cliff, and it's too late. We're going to talk about arrogance, overly self-importance, etc., etc. Here's a big one. The next point. People ask me, what makes the best expert in your opinion? And I sit as an arbitrator as well as being counsel, so I get to see both sides of the fence. And I would say, as the arbitrator, it's all about trust. It's all about, because at the end of the day, you're going to have to weigh up both experts. It's rare that it's a massive difference between experts. You're going to have to weigh up. They'll come down to small things. And in the end, you have to, using the language of preference, you have to prefer one over the other. And therefore, you ask yourself, who do I trust the most as the expert, as me, the decision maker? Who do I trust the most? And a real indicator of trust and not being a hired gun is the expert that makes appropriate concessions. Okay. So it's the expert when pushed in cross-examination will say, okay, yeah, I do accept that in the appropriate cases. So an example of that would be in the hypothetical, any question beginning with if Professor, blah, 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 would you accept? Yes, on that hypothesis, I would accept, etc. So notice appropriate to the facts and circumstances, and a concession. I'm going to show you that in a judgment in just a minute, but I wanted to flag that for you, that is a very good indicator of trust in an expert witness, and something we're going to return to when we think about cross-examination in part 3. Notice you have a responsibility as well to protect your expert from harming themselves. I'm going to come back to that as well at the end when we look at not throwing your expert to the wolves and what the Supreme Court says about what your job is in terms of educating the expert. Reputational risk, yeah. So you are to try and protect your expert and try not let them get put to the sword. When I ask people who are doing expert witness training, why do you want to do it? And they say, well, I've reached a certain level in my career. I am peer assessed. All my peers think I'm really good at what I do. I have all these publications. I teach people. And I now want to have the public accreditation, if you like, of being recognized in the public forum for my skills. And I say, okay, so why have you not done it before? Because I live in mortal dread that I will be heavily criticized by a judge, which will tear my career into pieces. And I say, okay. So do you think that if you do this training, you will protect or inoculate yourself from that? And they say, yes, hopefully. Now, I do a bit of this expert witness training, and people go through the furnace, feet to the fire in the furnace, forged in the fire, etc. And they come back afterwards and they say, oh, thank goodness. I say, well, how did it go? Were you okay? Were you criticized? Funnily enough, I've just been reading a judgment this morning where I worked with the expert witness. And the judge had said that she was thoughtful, considerate, and an excellent expert witness. Yes. So all of the help and assistance and training that she got has paid off. But that's what we want. We want to have the nice words said about them in public. This is a risk coming up here where it's not so nice. Now, this is a case from last year. You might have read about it, might have heard about it. House in Notting Hill. Georgian couple had bought it. Inside the house, they'd used kind of new age, newfangled sheep's wool as insulation in the walls, which had become infested with moths. There we are, moth infested. So 32.5 million mansion, and the surveyors who had come along and carried out the survey were said to have been negligent. So it comes before Mr. Justice Fancourt. Here's what he said about the expert witness. I was unimpressed. Yeah, let's take it halfway up. I was unimpressed by Mr. Sullivan's grasp of the matters in issue, which to a considerable degree I consider was work that had been done for him by his team, and with a detail of which he was insufficiently familiar. Yikes. I was unimpressed by his exercise of judgment, which seemed to me to be flawed in many instances, and by his approach to answering questions that were put to him. With one exception, which he later withdrew, he was unwilling to make sensible concessions. What did I just say? And consider in an open way whether his opinion should be qualified or corrected, and instead he argued with many questions of counsel and did not answer them, or in some cases try to answer them. Oh dear. The other witness was sensible and helpful, and he made, note, appropriate concessions when he realised that he was in error or where there was scope for a range of views. What did I say about tolerance, the plus or minus, the scale, etc., etc.? That is in the judgment. Obviously, that doesn't happen in arbitration, and it'd be pretty hard, I think, to be an expert solely in arbitration, but that is the living, working concern of experts that happens. Notice, just going back to that slide, notice the importance for that judge as a decision maker in the trustworthiness of Mr. Daly by virtue of his making of appropriate concessions. So I don't see that lightly. Okay. You will be aware of Jones and Caney. That is a liability, civil liability for damages for breach of implied duties of care to the party, or indeed express duties of care to the party. Has to be quite extreme before that happens, but I do point out to experts that that is lurking in the background. Now, we came in thinking about, well, why is it that we have the expert? Here's what Lord Justice Leveson said. My opinion is perfectly clear that expert evidence of doubtful reliability may be admitted too freely, with insufficient explanation of the basis for reaching specific conclusions, or it's challenged too weakly, or it's accepted too readily by the judge or jury at the end of the trial. In that regard, the law of England and Wales is not satisfactory, and reform is undoubtedly required. Strong words there. Now, you as practitioners, of course, are going to be thinking very carefully about why it is that you are commissioning an expert witness. This is the most important point to me, how that evidence fits within your overall litigation strategy or litigation plan. Now, let me show you this pyramid. Bring it up. Right. I use this in training experts in how to write a report, as you will see next time. I use this, and all my colleagues steal this, as an aid memoir to the cross-examination of expert witnesses. They will systematically work through from bottom left to the top, or they will jump around and challenge different parts of it. The purpose being in cross-examination to either knock out blocks in the pyramid, or what I call it, the ziggurat, either way, to knock out blocks and therefore make the whole edifice shaky in submission at the end of the case. My lord, his evidence was should not be accepted for following reasons, or indeed to collapse the entire pyramid, particularly that opinion at the top. So the opinion will be based or predicated on the reasons which follow the methodology and so on and so forth. Now, this is only to let you see it at this stage next time. I think in 2 weeks' time, we're going to be working with this extensively. But you'll see from what we've looked at today with Mr. Justice Cresswell and his principles in terms of what's in the RDC, the DIFC, all of this comes together to the point where, and my example of the plumbers, to the point where you do need to deal with the CV, experience and expertise. You do need to address some kind of self-analysis of independence and impartiality and bias. You do have to record, this is the expert, you do have to record instructions and what exactly they were asked to do. I have heard horror stories about cases that are lost. Fingers are pointed at the expert who has failed or his evidence is not accepted. It's not his fault, because what he's been asked to do by the legal team is not strictly what he ought to have been asked to do. I've seen it, or I've heard about it. Facts found now, and information. Now, this is a really important one, come back to it again, is relevant facts. You and I don't know what the relevant facts are. We think we know. We know what we have to prove in law to get our remedy. That's true. But those aren't necessarily relevant facts for the purpose of the expert opinion. So the expert has to be educated, schooled in not the birth mattress, but the relevant facts that you think are important. And the reason for that is, if any of them are missing, you're going to carry out an investigation and you're going to narrate what the investigation was. I had a site visit. I did this, I searched that, went there. If that still turns up a blank in terms of a relevant fact that you need, Mr. Expert, you're going to have to draw an assumption, right? Assumption is a secondary inference that's drawn from primary facts. That will always be a target for a cross-examiner to test the strength of the inference. But this has to be recorded. Next, you need to state what methodology you've adopted and why it's that methodology. What other methodologies? There are 4 ways to value a company. There are 3 ways of carrying out this exercise, whatever it is. I chose this one because. Next up, reasoning. As the judges say, if you don't have reasoning, it's ipsi dixit. And Latin, ipsi dixit. Simple words, mere words. And therefore it doesn't carry any weight. It is a reasoning. So I would say to an expert, you need to unpack your mind. What did you do? You've told us what you did methodology-wise, but what did you do? Why did you do that? I considered this, I did that, I ignored that, I brought in that, I spoke to that, etc., etc. It's almost like baby steps in terms of explaining what it is that you've done in carrying out your reasoning as an expert witness with that technical knowledge and expertise. That's the main body of your report, or it should be. That's the most important part. That's why you're here. That's why you're being paid. The opinion at the end should simply be, in my professional opinion, I answer question 1, yes, question 2, no, question 3, yes, maybe. Because the opinion is simply the end point of the reasoning. Now, if I look at it from the expert witness point of view, as we'll do next week, those are the blocks I would be wanting to see in the report. No leaps of logic, no missing documentation, etc., etc. In the third part, seminar 3, we're going to be using this to think about, well, how do we attack in cross-examination? What are the questions that we want to fire in order to loosen up the brakes, or indeed get that opinion from the top to come crashing down at the bottom? So that is the exercise for seminar 2, and that will be our exercise for seminar 3 next time. Final thought. I said that the Supreme Court has commented on your responsibility to your expert, and you do. I thought I would replicate the paragraph from Lord Reid and Lord Hodge. Making sure the expert performs his or her role. It falls in the first instance to counsel and solicitors who propose to adduce the evidence of a skilled witness. I pause there. In Scotland, they call them skilled witnesses. It's just an expert witness, right? To adduce the evidence of an expert witness, to assess. This is counsel and solicitors, you, yeah, and me. To assess whether the proposed witness has the necessary expertise, right? So that's our job, our gig. And whether his or her evidence is otherwise admissible, right? So it's not willy-nilly just grab any expert. We are under a duty, says the Supreme Court in the UK, to carry out this exercise before we even offer or tender or proffer expert evidence in the case. But this is a bit in red I wanted to show you. It's also your role and my role to make sure that the proposed witness is aware of the duties imposed on an expert witness. Now, to my mind, that means that you are under a duty to explain to the expert witness the kind of familiarization topics that I sometimes do with experts as to independence. We've talked about it, independence, impartiality, bias, duty primarily to the tribunal. And I would say go further in terms of how it is that they're going to be giving their evidence. What happens if you're asked this? This is important, not to practice the evidence, but to make sure they are familiar with the method or techniques of answering questions in evidence. There's a difference there. Can't coach them, but I I would suggest to you, following this, it's your role to work with them in terms of getting their best evidence most effectively given to persuade the decision maker. Right. Judges go on. The legal team, you and me, should also disclose to the expert all of the relevant factual material which we intend should contribute to the expert's evidence in addition to his or her own pre-existing knowledge. So I would suggest to you that, albeit it's 10 years ago, this case, that's forgotten. And it's, I have seen it many times where solicitors think that the expert will be absolutely fine. We'll send them on a familiarization course. They'll be fine. Where I'm going to suggest to you that's insufficient. That is not enough. That's not fair on the expert. Because as was said in this 2013 case, the expert had been thrown to the wolves without any proper protection or advice as to the nature of his role and his duties and potential liabilities. I endorse that. That is not something that the expert should be exposed to. Now, in light of that, that leads nicely into part two. I hope you come back for part two. In part two, I'm going to be discussing with you, how do you work with your expert? How is it you can help the expert in the writing of a report? How could we use that pyramid that we've just been looking at to help the expert format or put all the parts of his report and not miss out parts in his report to help him provide a cogent piece of evidence for the decision maker? It also follows, and sometimes people ask me, is there ever a cross-examination proof report? Answer, no. But you can make yourself a much easier life if you follow a particular way of doing it to resist the lines of cross-examination, even using the pyramid. So you will see that this will inform part two of the seminar. I look forward to doing that with you, and also part three, when we will be thinking about the practicalities of cross-examination. So I think that's 1 minute two. That's nice timing. I'm very grateful to you for your time and attention. I should have said at the beginning, and I'll tell you now, if you have any questions, fire them across to me or comments, and I'll pick them up at the start of part two. But for the time being, thank you very much, and goodbye.